Understanding the cost of capital is essential for legal professionals involved in business valuations, litigation, and corporate transactions. Courts and lawyers routinely apply concepts like WACC, cost of debt, cost of equity, risk-free rate, risk premiums, beta, and industry risk premiums to resolve disputes and structure agreements. This case study synthesizes all major cost of capital concepts from Module 3, illustrating their application in legal practice through real-world scenarios and landmark court cases. Each lesson is integrated into the legal context, showing how lawyers and courts use these financial tools to resolve valuation disputes, draft agreements, and assess risk in corporate finance. WACC Basics for Lawyers. No math panic needed. Concept: the weighted average cost of capital, WACC, represents the average rate a company pays for financing, blending the cost of debt and equity based on their proportions in the capital structure. For lawyers, WACC is a key tool to evaluate financial soundness without needing to perform calculations. Legal scenario: in merger negotiations, lawyers assess the target's WACC to ensure the acquisition price fairly compensates creditors and shareholders. They focus on capital sources, legal obligations, and contract terms rather than the math. Key point: WACC helps lawyers understand a company's financial health and risk profile, making it essential for valuations, negotiations, and litigation. Cost of debt is the effective interest rate a company pays on its borrowings, as outlined in legal agreements like bond indentures or credit contracts. For example, in a default scenario, the bond indenture specifies the interest rate, payment terms, and remedies like collateral seizure or debt acceleration. Legal counsel interprets these terms to advise on enforcement actions. Beyond finance, cost of debt is a legally enforceable obligation with significant consequences for breach, making it critical in litigation, negotiations, and corporate transactions. Cost of equity: what shareholders really expect. Concept: cost of equity is the return shareholders expect for investing in a business, reflecting both time value and risk. It is a critical input in discounted cash flow, DCF, valuations used in litigation and transactions. Legal scenario: in a shareholder oppression lawsuit, the court must determine the fair value of minority shares. Expert witnesses present DCF analyses using different cost of equity assumptions, debating what return is reasonable given the company's risk profile. The risk-free rate, like a treasury yield, is the baseline for required returns. The equity risk premium, ERP, is the extra return for market risk. In business divorces, experts debate using a 10-year or 20-year treasury as the risk-free rate and the right ERP for current conditions. Courts closely scrutinize these choices, as small differences can significantly affect valuations. Selections must be defensible and tailored to the case, or courts may reject them. WACC in valuation disputes. Courts demand rigor and transparency in WACC selection, as it can decisively impact litigation outcomes. WACC is the standard discount rate in DCF litigation. Courts, as in Re Cellular Tel, Shiplity, Delegate Sage 2022, scrutinize each WACC component and rely on expert testimony that is transparent, well-documented, and scientifically valid under the Daubert standard. The court's WACC choice can significantly affect valuations, making defensible, case-specific inputs essential. Beta and systematic risk for legal professionals. Beta quantifies a company's exposure to market systematic risk and is a critical input in the capital asset pricing model, CAPM, to estimate the cost of equity. In shareholder disputes, experts often debate using an industry average beta versus a company-specific beta, as this choice directly impacts valuations. Legal professionals must carefully distinguish between systematic risk, captured by beta, and company-specific risk, adjusted via SARP, to avoid double counting and ensure defensible, credible valuations in litigation and negotiations.